Good afternoon. Welcome to the February 11th edition of the Idaho Falls City Club. My name is Mark Young, and we are pleased to represent the Idaho Falls City Club Board of Directors, and we add their welcome to today's proceedings. My first item on my agenda would be to thank our sponsors, and so let me be about that very pleasurable duty. In no particular order, because these folks are all number one in our eyes: the Bank of Idaho, Idaho State University, along with KISU, and at some point we'll get back to our normal venue at the University Place. We also appreciate Fluor, Idaho, the Idaho Humanities Council, which has clearly been a stalwart for us since the beginning, the Idaho National Laboratory, one of our longtime supporters as well, Mountain View Hospital, more recently joining our ranks of civic supporters. We thank them very much. In addition, today, I would like to give special thanks to IE Productions. We are at their facility yet again, and we give them great thanks for their support, for providing this platform for the Idaho Falls City Club as we speak. And in fact, Chad Hammond, the proprietor of IE Productions, is our newest board member for the City Club of Idaho Falls, and we welcome Chad and his expertise to our mission. I'd like to have you circle your calendar for some upcoming events for our City Club. Indeed, February 26th is just around the corner, and the Idaho Falls City Club will host the Director of the Department of Health and Welfare, Dave Jepson. He will give us an update on vaccines regarding COVID and the status of all things about the pandemic and how we can, our last final efforts of vaccines for our state, and that'll be on the 26th of February. Director David Jepson from the Health and Welfare Department. We have other programs coming up, but it's too soon to announce time and place, but I can assure you we have some outstanding programs coming to us with our City Club. Today, we gather in a virtual world to understand the reality of our circumstance. We remain in a pandemic which has not only stretched our healthcare system, but has also our humanity and also our legal system itself. We currently are in an impeachment trial, the result of violence turned upon ourselves that sought to harm our very foundation as a nation. Today, we seek understanding and wisdom, perhaps even assurance, that our bonds, our system, will hold tight through these difficulties. To lead us forward and introduce our distinguished guest, we turn to the president of the Alturas Institute, President Adler, also a founder and a current member of the City Club Board of Directors. We also know him to appreciate him as a bright light for constitutional studies, not to mention his scholarship and civic engagement that we all look to Dr. Dave for our help in these difficult times. Ladies and gentlemen, please welcome Dr. David Adler.
Thanks, Mark, very much for that warm welcome. It's a pleasure to be able to join all of you again today, and the moment could not be more timely for us to host our distinguished Attorney General because we are caught in the clutches of many political, legal, and constitutional crises in America. And many are paying very, very close attention to the events in Washington. But as you all know, there are a few interesting legal and political and constitutional events occurring in the Idaho State Capitol, and we may be able to solicit a few comments today from our Attorney General. Our guest today is no stranger to any of you. In fact, he's a friend of the City Club. He has been a participant in City Club programs on several occasions, and we're delighted today to introduce the Attorney General of Idaho, Lawrence Wasden. He is, of course, Idaho's 32nd Attorney General, and he was elected to his fifth term in office in 2018. He is the longest-serving Attorney General in the state of Idaho. He first joined the office of the Attorney General in 1989 as a deputy assigned to the Idaho State Tax Commission. He was elevated soon thereafter to the post of Deputy Chief of Staff and Chief of Staff before running for and successfully securing the office of Attorney General in 2002. Before that, of course, he enjoyed significant prosecutorial experience as the prosecuting attorney in Canyon County and the prosecuting attorney in Owyhee County. He is the recipient of numerous awards and prizes, the sort bestowed upon the most highly achieving attorneys general across the nation. For instance, he is past president of the National Association of Attorneys General, marking his national prominence. And he, of course, has also been honored by his colleagues here in the West, first as past chair of the Conference of Western Attorneys General, and the recipient of a prestigious award in 2010, the Courage in Public Service Award. He has also been He's also the recipient of the Lifetime Achievement Award for Leaders in Law program presented by the Idaho Business Review and numerous other prestigious awards. He is a recipient of degrees from Brigham Young University and the University of Idaho. And of course, he and his wife Tracy, who were married in 1980, they have 4 children and 13 grandchildren. Our talk today, presented by Mr. Wasden, has a special resonance in these times. And the title, of course, is The Rule of Law in America, a Principle for All Seasons. Mr. Attorney General, it's a delight to have you with us today. Thanks very much for taking time out of your very busy schedule to join us.
Thank you, Dr. Adler. And I wanted to compliment you. You and I have worked together when you were at the University of Idaho, when you were at Boise State University, and during your current responsibilities. And I recall an occasion in which you appeared before the legislature. Someone referred to you as a self-appointed expert, and the members of the committee corrected that and say you were indeed an expert. And so I recognize your tremendous expertise and your contribution to the state, and I wanted to publicly say thank you for that.
Thank you, sir.
Also, I wanted to give compliment to INL and its new director, and also to Fluor, Idaho. And previous occasions when I've come before this body, we've been talking about some matters at INL. Those folks are incredible, amazing, talented, and they've done tremendous work. As you know, we've reached an accord with regard to some of the issues we had out there. I couldn't be more pleased and couldn't be more happy with the work that I see going on with at INL and with Fluor. So I wanted to compliment them publicly as well. And our subject today is to really talk about the rule of law. And when I started as Attorney General many years ago, I had 5 things that I wanted to accomplish. One was to conduct firm and fair criminal prosecutions, to protect Idaho's water and sovereignty, to protect Idaho's consumers from fraud, to pursue wise stewardship of state endowment lands to obtain the maximum long-term financial return, and finally, to ensure justice for all Idahoans. The basic principle that underlies all of those issues is my dedication, belief in, and observance of the rule of law. The rule of law can essentially be summed up by a phrase that we often use, which is nobody is above the law. And sometimes we forget about what that means. In a governing system based on the rule of law, everybody is equal before the law. In contrast, the system that is based upon tyranny or monarchy or oligarchy, those systems occur when a governance is to a single person or to a small group of people. The World Justice Project points out, let me get a little marker up here for you. There we go. Let's change that to this. That is the World Justice Project points out that effective rule of law itself depends upon the following 4 principles. Just want to point them out. That is that the law applies to everyone, that the laws are not secret or arbitrary, that they are fairly enforced, and that the system of justice is fair. And I want to kind of take those and apply them in some of the events that have occurred or that have recently occurred. So I'd really like to concentrate on talking about a case that was of great profile. It's called Texas versus Pennsylvania. It occurred about 2 months ago. It consisted of the state of Texas suing 4 states, Pennsylvania, Georgia, Michigan, and Wisconsin, over the way they ran their elections. And it dominated the news media for several days. And many of my Republican colleagues around the country joined that lawsuit, and I did not. And ultimately, on December 11th, the United States Supreme Court did not find for Texas. In fact, it disallowed their filing the lawsuit at the outset. And I want to discuss with you the reason why I did that and how the rule of law applies. So first of all, I'd like you to take a pencil and a piece of paper, and I want you to do a calculation. It's a calculation on a riddle. And I'm going to show it to you in just a second. I don't want you to shout out the answer. I just want you to take a moment and consider this and do a calculation. So here's the riddle. You have 5 cows, 2 dogs, and 1 cat. How many legs do you have? Now, I'll give you a moment to do that calculation. So you've had a moment. Shouldn't have taken you too long. 5 cows, 5 times 4 is 20. 2 dogs, 2 times 4 is 8. That's 28. 1 cat, 32. 4 legs, that's 13. 28 plus 4 is 32. So how many of you answered? This is a rhetorical question. How many of you answered 32? And the answer is, that's wrong. That's wrong because the answer is 2. Why is the answer 2? Why is my phone ringing? That's an even better question. The answer is 2 because in order to get the right answer, you have to identify the right question. What's the question being asked? And despite the reference to cows and dogs and cats, the actual question being asked is, how many legs do you have? So the answer is 2 rather than 32. In the legal sense, we have to also identify the right question. What question is being asked in any given set of circumstances, in any case before a court? If you don't identify the right question, you won't get the right answer. And that question isn't what is developed by Fox News or MSNBC or talk radio or bloggers on the internet or on Facebook or any place else. It is what really is the core of the question being asked. So we're going to, as we talk about this whole issue, there's a few basic principles that we need to talk about. One of those is the separation of powers. This is stuff we learned when we were in 3rd grade. And there are 3 branches of government. I want to take a moment and just explain that the term separation of power and 3 branches of government, those terms do not actually appear anywhere in the United States Constitution or in our state constitution for that matter. How is it that we get separation of powers? It is because in our Constitution, in the language itself, Article 1, Section 1 says the legislative power is given to Congress. Article 2, Section 1 says the executive power is in the President of the United States. And Article 3, Section 1 says that the judicial power of the United States shall be vested in one Supreme Court and such inferior courts as the Congress may from time to time ordain and establish, meaning that the judicial power is held by the judicial branch. So it is the structure of the Constitution itself, the language itself, that separates those 3 branches of government and separates those powers. It's the words do not appear themselves. Another concept we need to talk, before I move on, in these 3 branches of government, in the legislative branch of government, we discuss policy issues. Is this a good law? Is this a bad law? This is what I think. This is what I think. This is what you think. That's where we have that kind of forum where we talk about what is the policy, what the law should be. In the judicial branch of government, we're not talking about what should the law be. We're talking about what is the law? The arguments that we make in a legal forum are legal arguments. They're not the policy arguments that are submitted in the policy forum. And I can take time and draw that distinction even better, but I hope that suffices for the purposes of our argument, our discussion, that the legal arguments are different from policy arguments because the forum is different. I'd also like to talk for a moment about the term federalism, and we oftentimes understand it, but or say it, but I'm not sure we always understand it. And the definition of federalism, this is just a dictionary definition. It's having or relating to a system of government in which several states form a unity but remain independent in internal affairs. So there's two elements here. The original states formed together after the Revolutionary War and after the Articles of Confederation simply were failing. It is then that the states gathered together and then created a constitution. Oftentimes we forget about the Articles of Confederation, and that's significant. So that the states formed a unity. That's a national government, but each of those states remained independent in their internal affairs. So what does that look like? It looks like this. We have a sovereign national government. We happen to call that the federal government. But then we also have 50 sovereign states. So in this country, we live under dual sovereignty, a sovereign national government and dual sovereign states. That's not typical among the world because that is a lot of countries around the world really can't envision this concept of dual sovereignty, where I'm a citizen of a state and I'm also a citizen of the United States, and I have allegiance to both of them. In that concept of sovereignty, it's significant to understand that each state is sovereign from every other state, that one state does not direct or control what happens in another state. And so we live under the principle of federalism, which really is represented by what I have on the screen right now. Another issue that we need to talk about is the 10th Amendment. And what it says is the powers not delegated to the United States by the Constitution, that's one thing, nor prohibited to the states, that's another thing, are reserved to the states, that's another thing, the states respectively, or to the people, that's another thing. I like to refer to that as the buckets of power theory of the 10th Amendment. This isn't any national known theory. This is my theory, but it's the way I describe the 10th Amendment. But there are respective buckets of power that their Constitution places power into the federal government bucket. One of those powers we already talked about, that is the judicial power, is a power that the Constitution grants to the federal government, the judicial branch of government, but it is a power held in that federal bucket. It is not prohibited to the states. There are powers that the Constitution prohibits the state from doing, like violating equal protection, for example. And there are other powers that are reserved to the states respectively, and others yet that are reserved to the people. The Constitution doesn't define those that are reserved. It says they are reserved. But if the power is in one of those buckets, in the federal bucket, for example, then it is not a power that is reserved to the states. And it is not a power that is reserved to the people. And sometimes we forget that if it is a committed power, then it is effectively removed from the other buckets. Some powers, for example, in a federal system of dual sovereignty, the federal government has the federal judicial power and the states have a state judicial power. Those things are complementary, and ultimately the state is still subject to the federal Constitution, but each of them have their independent judicial power as a sovereign. So there is also, we talked about this Article 3, Section 1, the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. It's also important to understand Section 2 of Article 3, which says that the judicial power, whatever that is, extends to all cases in law and equity arising under this Constitution. This is the jurisdictional province of the court. So when a question arises under the Constitution, it says that the United States Supreme Court gets to answer that question. And it also says that the judicial power extends to controversies between two or more states. That's the underlying portion. That's significant because when one state sues another state, that is what's called an original action in the United States Supreme Court. Typically, a person would have to file in the district court and then appeal to an appellate court and then go to the United States Supreme Court if the court chose to take the case. However, when it is one state suing another state, that's an original action in front of the United States Supreme Court. Now, with regard to the general allegations of fraud, general allegations made concerning this Texas case, there were really four areas, and myriads of kinds of statements made. But I want to talk about four of them at the outset. One of them was the allegations of election fraud. Two, the statement that was made to me repeatedly, as well as the election fraud, was that the lower courts wouldn't hear the cases. And I want to talk about that. I want to talk about the constant discussion of the diminishment of electoral college votes. And also, the fourth one is undermining the U.S. Constitution. I want to talk about each of those briefly, and then we'll talk about the case in and of itself. So let's talk about election fraud. This is not a legal question. This is actually a factual question. The factual question is, did it happen? Now, you and I have seen the videos, we've seen the news reports, all of that stuff, giving rise to questions. So the question is, did it happen? Well, when I was asked to join the Texas lawsuit, I was asked to allege that fraud had occurred. Here's the problem. I wasn't in those four states. I wasn't in Pennsylvania, Georgia, Wisconsin, or Michigan. In fact, my client, the state of Idaho, wasn't in those states either. We were here in Idaho voting. And so I can't make a personal allegation of fraud. Again, I'm not saying it occurred or it didn't occur. I'm saying that the evidence that I would have would be secondhand. It would be hearsay. I don't personally know that that fraudulent activity occurred. I'm not saying it didn't. I'm not saying it did. I'm just saying I can't make that allegation. Why is that significant? It's significant because when I file a complaint in federal court under Rule 11, it says that when I sign that complaint and I file it, I'm asserting that I know there's a factual basis for that allegation. And I can't do that. In fact, my bar license is on the line if I falsely make that allegation. It goes further and says, or after reasonable investigation, I believe that there would be factual allegations, sufficient factual allegations. Again, what that would require me to do is to go to those other states, and I would have to depose their legislators and their governor and so forth. And that's where we begin to have the problem. So on the issue of fraud, if it occurred, I don't have the personal knowledge that allows me to make that allegation. With regard to the second issue, that is whether the lower courts wouldn't hear the cases. Again, this is a question of fact, not a question of law. That is, either they heard the cases or they didn't. That's just a function of factually, did it happen? There was somewhere between 50 to 60 different lawsuits that were filed. I think the number is like 58, somewhere in that neighborhood. And each one of those was unsuccessful. They resulted in one of two outcomes, except one is still in play. But the outcome is this. A number of them, they were filed, and then the parties filing it withdrew the case. The rest of them, the courts heard the cases. That is, complaints were filed, affidavits were filed, the court heard oral arguments, and the court in each instance dismissed the case. The fact that a case is dismissed doesn't mean the court didn't hear it. And in fact, if you think about a lawsuit, in every case, somebody wins and somebody loses. And the person who lost can't say, well, the court didn't hear my case. Maybe they disagree with the court, but that fact that they lost the case doesn't mean the court didn't hear it. And in fact, having 50 or 60 courts look at the case and look at the facts and say, there isn't fraud here, then that's a very significant matter. And why is that? It's because the court is the judicial body that has the power to make that decision. It is the court is the entity that receives that information and then by constitution has the power to answer the question that has arisen under the Constitution. And so they're the entity that has the power to make that decision. And the rule of law then requires us, whether we agree or disagree with the outcome, we're required by the rule of law to accept that. It doesn't mean we have to agree. I often disagree with courts when they make decisions. But I am subject to the law as it's enunciated by that court. We'd like to talk for a moment about the diminishment of electoral votes. Some people claimed, and very vociferously, that Idaho was disenfranchised by what happened in those other states. The term franchise means the right to vote. In Idaho, we were not denied the right to vote, so we were not disenfranchised. But there's a second half of that argument, and that is the argument that Idaho's electoral votes were impacted or diminished because of the way in which other states held their elections. And the allegation is that those elections allowed electoral votes to be cast based upon a dubious or improper or fraudulent process to select those electors. So then the question becomes, who gets to decide if those votes were selected in a dubious or improper fashion? And again, the answer is that it is the judicial branch of government that gets to answer that question. It is a question that is arising under the Constitution. And that is the judicial power is the power to decide that. So again, of the 50 to 60 courts that heard those cases, they said, we have examined the evidence and we find that there's not fraud. Now, to establish that in front of a court, you have to do more than have a national press conference for 90 minutes and saying we've got gobs and gobs of evidence. You actually have to take that evidence and submit it in the courtroom for a court to make that decision. So both federal and state courts that have considered this have said we do not find fraud. There is one case that's still in front of the United States Supreme Court on this issue, and we'll have to see what the court says. The next issue was the undermining of the Constitution, and the argument here is that the Constitution is undermined if we rely upon those dubiously or improperly acquired votes. Now, let me tell you, this is a serious allegation. And the answer is this, that voting is a human endeavor. That means humans are involved in this process, and there are going to be mistakes. So that even though perfection may be the goal, perfection really is not ever obtained. I don't think there's ever been an election which was run absolutely perfectly. I would suspect that there will be some sort of bobble somewhere in the system in which humans are running it. So the real question then becomes, what is constitutionally acceptable as a vote? Let me give you an example. If you have 1 million votes cast and 999,999 of them are done properly and one vote is fraudulent, does that one fraudulent vote outweigh the 999,999 valid votes? I would suggest that it doesn't. Conversely, if you have 1 million votes cast and you have 999,999 fraudulent votes and one valid vote, do you allow those 999,000 votes to outweigh the one vote, the one valid vote? And I think that valid vote is valid. But given that those parameters, the court has got to say what is constitutionally acceptable in that framework of we can't get perfection. It's unlikely to have perfection, but yet we have to see that the system is run properly. And again, the courts are the ones who have the authority to make that decision. They've made that decision, and the rule of law is incumbent upon us to adhere to the rule of law. So I want you to remember a minute the riddle. That is, you have to identify the actual question. So what is the actual question that was being asked in the Texas lawsuit? Now, they had a question that they named, and we'll talk about that in a minute. But what was the actual question that was being asked? And this is a federal issue, and it's the critical legal issue. It is the question that was being asked, and it's this: can one sovereign state sue another sovereign state for the defendant state's exercise of its sovereign power? Now, what do I mean by that? It is the sovereign state of Texas who is suing 4 other sovereign states because of their exercise, and under the United States Constitution, selection of electors is a state power. That's specifically what it says. It says the state is to set forth a manner of electing electors as provided by the state legislature. So the question is, or the critical issue here is that is a state power. So the question is, can Texas sue those other sovereign states for how those states exercise their state power in selecting electors that elect the president of the United States? Now, this question has to be answered yes. It has to be answered in the affirmative before the court can move on to other substantive issues. So as I looked at this question, can the state of Texas sue those other states? The concept of federalism comes right to the forefront. And that is, can we in this dual system of sovereignty sue another state? Sovereignty, as we've said, our sovereignty means the supreme power, especially over a body politic, and it is freedom from external control. It is autonomy. That's what it means to be a sovereign. That is the corollary to that is the concept of federalism that says in federalism, states have create a national government, and each of those states is separate from all the other states. As I mentioned, Article 2, Section 1, Clause 2 confirms that the election is a state power. And so then the question is it a violation of federalism for one sovereign state to sue another sovereign state for that state's exercise of its sovereign constitutional power concerning elections? And the answer is really no. The state cannot sue another sovereign state for the defendant's exercise of its sovereign power. To do so would violate the principles of federalism. So what is it I said? How did I answer this question? And this is my statement. It's a couple of paragraphs, 6 total sentences. And I've said I've spent a lot of time reviewing this bill of complaint. After doing so, I'm declining to join this effort. Why? Well, as sometimes the case, the legally correct decision may not be the politically convenient one. My responsibility is to the state of Idaho and the rule of law. This decision is necessary to protect Idaho's sovereignty. Idaho is a sovereign state and should be free to govern itself without interference from any other state. Likewise, Idaho should respect the sovereignty of its sister states. What is it that the United States Supreme Court said? This is the entire decision by the United States Supreme Court in Texas versus Pennsylvania. It's 2 major paragraphs, 6 total sentences. So let's read what they said. They said Texas's motion for leave to file a bill of complaint is denied for lack of standing under Article 3 of the Constitution. What does that mean? That means Texas, you can't file a lawsuit against your sister states. One sovereign cannot sue another sovereign. Why is that? He said Texas has not demonstrated a judicially cognizable interest in the matter in which another state conducts its elections. It says Texas, you can't sue another state for how that state exercises its constitutional authority. And it went on to say all other pending motions are dismissed as moot. What does that mean? That means that the question being posed, the other questions, really are not a case or controversy under Article 3, Section 1 and 2 of the United States Constitution. As a consequence, the court doesn't answer moot questions. It doesn't give answers that are figurative. It only answers actual questions that are being posed to the court. Now, recognize that Justice Alito and Justice Thomas, they didn't oppose this. They actually agreed with the court, but on slightly different means. And that is, they said, in my view, we do not have discretion to deny the filing of a bill of complaint in a case that falls within our original jurisdiction. What that means is, I read you the language of Article 3, Section 2, and they say, yeah, Texas, you can file the complaint because we have to accept all of them. there's a dispute on the court whether they have to accept it or not. These two fall in the category of we should accept it. The other said, no, we don't even have to accept it. But listen to the rest of their words. They then said, I would therefore grant the motion to file the bill of complaint, but would not grant other relief. Meaning, yeah, you can file it, but you're not entitled to any relief because you haven't stated a cause of action against your sister state. You, Texas, a sovereign state, cannot sue your sovereign sister states. Now, let's think about that for a minute. If Texas can sue Pennsylvania for Pennsylvania's exercise of its sovereign power, then California can sue Idaho for our exercise of our sovereign power. And I don't believe that California, New York, Illinois, or Massachusetts, or any other state should have the right to interfere in Idaho's exercise of its sovereign power. But that's precisely what I would have been doing on behalf of the state of Idaho, my client, had I joined the Texas case. Now, there were some other arguments, many of them. Some of them are vulgar. And in fact, my mother told me when I read some of them to her, she told me she'd wash my mouth out with soap if I repeated to people the vulgarity with which people addressed me. But I'd like to address some of the other arguments. One of them is, well, you should have joined Texas to show solidarity with other Republican AGs. As I mentioned, the court doesn't count noses. We count noses in the legislative branch of government. How many voted for it and how many voted for against it? And that's where we, write our congressmen and write our legislators and that sort of thing. The justices, however, there are only 9 noses that count, and that's the 9 noses on the court. And my nose doesn't count, and your nose doesn't count. Whether we agree or disagree with what the court does doesn't really make a difference, because that's not the process in the courtroom for making that decision. Some people said, well, what about other state AGs? They joined and Idaho didn't. Why is that? Well, I don't answer for those AGs. They made their own decisions. My job is to defend the Constitution, and I did that. Some of those same AGs, I will tell you, have privately acknowledged to me that they made the wrong decision, that they, in fact, made it for a political reason rather than legal reasons. Just yesterday, a lawyer talked to me and said, well, he really wished that we would have joined and wished the outcome of that case would have been different. And then he said to me, but I know you did what was based on the law. I don't know that I would have had the courage to do what you did. Some people said, well, very angrily, well, you didn't represent me. The answer is, I don't represent people as individuals. I represent 1.7 million people as a whole and not individuals or groups of individuals. And so I don't make that choice based upon how many people believe on one side of an issue, how many believe on the other. It is what is the law, because it is the rule of law that guides my decision making. Some people said, well, you should have joined because you represent the state and the Republican Party. And by law, I represent the state, but I do not legally represent the Republican Party, the Democrat Party, or any other party. My job is to the Constitution, it is to the laws, it is to the people of the state, it is the state as a whole. Some people have said very strenuously, Trump is going to win this case. You should be on the right side of history. The answer is Trump didn't win the case. And I'm on the right side of the law, which is where I'm supposed to be. And whether I'm on the right side of history remains to be seen. And whether I'm on the right side of history or not is a policy choice that is not consistent with the rule of law. I should make my decision based upon what the law is, not whether people think I'm on the right side of history or not. Some people said, well, you're supposed to support President Trump. Well, my oath of office is to support and defend the Constitution and the laws of the state of Idaho, not an individual. Some people said, well, I'm not going to vote for you. We're going to throw you out of office. And that is your right under the very Constitution that I have taken a political and public beating to defend. My choice, again, is based on the law, not on whether you're going to vote for me or not. And my oath of office is to defend the Constitution. It's not to seek your vote. I'm sorry you've made the choice you have, but you have the right to make that choice. A number of them said, well, you're a coward and you don't have the courage to be the Attorney General. I guess you and I have very different understandings of the word courage. Being a sheep and just following the crowd doesn't take courage. but standing alone and defending the Constitution does. One of my heroes, Abraham Lincoln, said, "Be sure to put your feet in the right place and then stand firm." And that's exactly what I did. With that, I thank you for the opportunity of listening to me, and I open it up for whatever questions you may pose and have for me.
Great. Wonderful. Thank you, Mr. Attorney General. We deeply appreciate your very thorough review of Texas versus Pennsylvania, which captured the passions and imagination of Americans everywhere, and your discourse on the vital role of the Attorney General in upholding the rule of law is illuminating, because I want to ask you a question. If, in fact, you were to decide to defend laws based on your own policy preferences, your own politics, your own ideology, what would happen to the principle of the rule of law over time?
First of all, I'd be the king. And I'm not the king. I wasn't elected to be the king. I don't have a crown. What would happen to the rule of law is it would no longer be the rule of law. It would be the rule of whim. You know, oftentimes the legislature will pass statutes with which I may personally disagree or I may personally agree. And I advise them either it fits within constitutional muster or it does not. And they pass the law anyway. And my obligation is to defend that statute. It's to make the legal arguments, not the policy arguments, the legal arguments to defend that statute. And if I get to choose whether I'm going to defend it or not, I'm the guy ultimately that's making the policy choice, if you think about that. And that's a violation of separation of powers. It undermines the policy choices made by the legislature, and that's not proper. That's not what my role is. I'm obligated to tell them straight up and down, I think this will pass constitutional muster, or I think it won't. And despite that, I am also faced with the duty and responsibility under the law to make the legal arguments to defend that policy. So the basic answer to your question is, if I'm the guy who makes that choice, what I'll defend and what I won't, ultimately, we don't have the rule of law.
And to your point, Mr. Attorney General, if we mark the end of the rule of law, the same problem or the same dilemma that you or somebody in your chair might face is often the same problem, and Americans recognize this, that's presented to the Supreme Court or any court. If the judges were allowed to decide the meaning of the law based on their own preferences, their own biases, their own ideology, would that not mark the end of constitutional government in this country and the end of the rule of law?
Absolutely be the end of constitutional rule, and it would be the end of constitutional law. When you think about that separation of powers concept, that is, the policy-making function is in the legislative branch. If the judiciary becomes the policy-making body because they're saying what's good law or bad law, then they now are doing what the legislature is supposed to do, or our Congress is supposed to do. And if that happens, then why do we have a Congress anyway, if it's just going to happen in the judiciary? And conversely, if the legislative branch of government thinks that they can make the decisions about the constitutionality of questions that arise under the Constitution, why do we have a judiciary? That strict separation of powers is really what allows us as people to be a free people, because we're not subject to the whims of one of those branches of government. That really is the critical point of the rule of law.
And so I think you've seized upon a problem sweeping across the country in our time or any time, and that is, as you well know, Idahoans, like Americans from coast to coast, revere the Constitution. They consider it in many places to be a sacred document, and they sing its praises. But is it the case that you've found over your many years in holding this high office that maybe Americans don't quite appreciate the virtues and values of the rule of law and American constitutionalism when they ask you or somebody in your seat to essentially make choices on a political basis rather than a legal basis?
That is absolutely the point. And I kind of tongue-in-cheek say it this way, that many times people claim to believe in a constitution they refuse to read. And that is, I sat in my office on one occasion with a legislator. He's now deceased, but he was really railing on me because I wasn't doing what he wanted me to do, and I wasn't answering the questions the way he wanted me to answer them. And it had to do with the judicial branch of government. This is an individual who had a pocket copy of the Constitution. He kept with him at all times. And I said to him, pull out that Constitution and read Article 3, Section 1 about the judicial power being granted to the federal Supreme Court, United States Supreme Court. And because what he was wanting me to do was he was wanting me to say that the Idaho legislature could violate that very principle. And I said, no, they can't, and I cannot tell you to do that because that would be a violation of my duty to defend the Constitution. He was very, very angry with me. But we need to pull out the Constitution and recognize that we have to read the actual words, the words that are written, not the words we think should be written, but the words that are written, and recognize also that it is the court who gets to say what those words mean. And so even though I may disagree with the court, and I often do, but I'm still bound under the rule of law to live by what they say until such time as either the statute or the Constitution is changed or the court changes its mind. That there's no other way that we would continue to have the rule of law. So I hope that answers your question.
It does.
Doctor.
Thank you. And to return, Mr. Wasden, to one of your early points about Texas versus Pennsylvania, when you pointed out that given your office and given Rule 11, you cannot put your name on a lawsuit attesting to allegations if in fact those your position is falsely made. Your bar license would be on the line. And then you went on to point out that roughly 60 cases, a combination of federal and state courts, ruled that there was no evidence indicating significant fraud in the country. As you well know, many of the attorneys who brought the lawsuit on behalf of President Trump refused to rise to the bait when judges said to them, frankly, do you have any evidence? And they withdrew because perhaps of what you stated earlier. They didn't want to have their legal careers on the line, despite the fact they would then hold a press conference and, of course, continue the fabrications about sweeping fraud across the country. What do you make of attorneys? You're an officer of the court, you're a veteran attorney general. What do you make of attorneys who would make an argument and fail to present any evidence because it doesn't appear, and yet go outside the building and then to continue to spread falsehoods about sweeping fraud?
Yeah, what I have to do is I have to measure my own conduct, and I have to look at myself in the mirror, and I have to like what I see, and I have to measure my conduct by the rules of ethics that control the behavior of attorneys, and I have to meet my own moral compass, and so I've acted in accordance with those ethical rules and that moral compass, and I have concern. I'm not going to say I don't know what evidence those other attorneys had. I don't know what they were privy to. And so I can't really judge that on that face in that way. But I do think it's very important that attorneys recognize the significance of when they make those allegations, that they are sufficiently supported by facts. That's what the rule requires. And I'm not going to condemn any others, but I do believe that it's incumbent upon me to live according to those rules, and I've done so.
Thank you. As you pointed out, constitutional law cases often fall in the intersection of law and politics, and we are witness to a great Senate trial on the question of whether or not President Trump should be convicted of the impeachment charge against him. So I'd like to turn to you for a moment on a couple of questions on the forefront of everybody's minds about this impeachment trial. And I may ask you to forecast a little bit because, again, you're not there on the scene. But do you consider that the president's speech would fall into the category of incitement to insurrection. We only throw you softball questions here at the City Club of Idaho Falls.
Gee, thanks. Thanks. I can't say that I have familiarized myself with every single thing that the president said. But there are a couple of issues in play here. One of them is that the president of the United States doesn't somehow surrender his First Amendment right. And we also know that there's a limitation to that First Amendment right. One of the famous court cases said that the First Amendment right doesn't protect your ability to yell fire in a crowded, falsely yell fire in a crowded theater. So that is actually a matter of both fact and law. And I'm not going to venture a guess as to the outcome of that. I think there's a couple of other bodies that are going to make that determination. People can make their own determination, but even speech is protected, even if it's false. It is still protected speech. Whether that rises to the level of incitement, that's, I guess, for someone else to decide. I would also make this comment, and that is under Article 1, Section 2, Clause 6 of the Constitution. I just wanted to read that. It says that, am I right? Clause 6, I believe. Hold on. Section, let me get it. It'll take me a second. Article 1, Section 2, Clause 6. There we go. But there are only 5. Hold on, there we go. Here it's under Section 3, I'm sorry. The Senate shall have sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside, and it goes on to say some other things. So the question I have at the outset of this is, the articles of impeachment were passed by the House. Donald Trump was president at that time. But what the Constitution is saying is that when it's tried in the Senate, then the Supreme Court justice presides. And I raise this as an issue, and that is the President of the United States is not being tried in front of the United States Senate. Donald Trump, a private citizen, is now being tried, but he's no longer the president. And I just point that out. That's what the language of the Constitution says. And Dr. Adler, you're actually a far better expert on this issue. I've heard some of your speeches on this matter, and there is some history as to persons who were impeached. Trials of impeachment were occurred after they left office. But I think that there's some significant questions. I think the Chief Justice has a significant question about the propriety of what's going on, because he's not there, because I'm certain in his view, the President of the United States is not being tried before the Senate. It is a private citizen. So I think that there are some significant legal questions. I'm not sure that this process, from a wholly public perspective, I'm not sure that this is a healthy process for the people of this this union to come together. But I also don't control the Senate. It has its powers, and it's going to proceed as it sees fit.
Thank you. We appreciate your discretion and your discernment. Let's shift in our remaining moments to some political, legal, and constitutional controversies here in Idaho. And of course, your office is at the center of many of these. It almost seems inescapable to you, I'm sure.
Yes.
As you know, and you could enlighten us a little bit, some resolutions in the House have attempted to undercut or to limit the governor's emergency power. And I think your office issued an opinion on the effort by the State House to resort to concurrent resolutions to do a number of things, including ending the governor's authority to declare an emergency. Could you tell us a little bit about the legal opinion issued by your office, please?
Yes. So first of all, I think we need to look at the basics of the Idaho State Constitution, which gives the legislative power to the legislature. And the legislature exercises that power by a bill starting in one house, passing that house, going to another house, passing that house. It's called presentment. It's presented to the governor, who can then either sign it into law, veto it, or allow it to become law without his signature. That is the process under the Constitution for the legislature to make a law. If the governor vetoes it, that law can go back to the legislature, and by a supermajority, the legislature can override the veto. That is the checks and balances. That's separation of powers. That's everything that's envisioned by our founding fathers. In this circumstance, a number of years ago, the legislature amended the Constitution with regard to, it's HJR 5, amended the Constitution with regard to rules. Now, it's important to understand how rules come about. The legislature, by law, it passes a statute, which goes through that normal process, and passes a law and said, you, executive agency, you shall pass rules, or you may pass rules. It comes in those two flavors, but most often it is executive agency, you shall pass rules. And those rules fall under the Administrative Procedures Act, and the authority for those agencies to adopt them is within the confines of the Administrative Procedures Act. Now, by the way, I opposed HJR 5, but my opposition, and I've received political retribution for that. But the reason I opposed it is the legislature said, we don't like executive agencies making rules. And my answer was, then stop telling them to make rules. Stop giving them your power and then complaining that you don't like how they're doing it. Quit separating the decision-making responsibility, the duty to make the rules, from the responsibility for making the rules, because that's what you're doing. In fact, I said that to a legislator. He said, well, if we did that, we'd have to make hard decisions. And the answer is, yeah, the ones you were elected to make. So given that, the legislature proposed the constitutional amendment, which was voted down once, and then was ultimately they proposed it a second time, and it went in, was adopted by the people. It's part of our Constitution. It allows the legislature to use the concurrent resolution to deny rules. So here's the argument that some people have made. The governor issued an order, and the director of the Department of Health and Welfare issued orders concerning COVID-19. Some have argued that those are rules under the Administrative Procedures Act and therefore can be rejected by concurrent resolution. Here's the problem. The governor's authority to issue executive orders doesn't come under the Administrative Procedures Act. It comes because the Constitution makes him the chief executive officer. It is a constitutional authority. So it isn't subject to that statute. And furthermore, the statutes allowing the governor and the director of the Department of Health and Welfare to issue these orders do not come from the Administrative Procedures Act. They come from separate code sections that are different chapters and different code sections than what applies under the Administrative Procedures Act. So the question then presented to us, it's a legal question, is can the legislature by concurrent resolution amend or repeal executive orders and orders issued by the director of the Department of Health and Welfare? Our answer is no, because that would allow the legislature to act outside the scope of the constitutionally mandated process of passing a bill before both houses and presenting that bill to the governor. We'll see what the answer is. I think that we're on pretty good ground in the advice we've given. That's made some people very angry. They don't trust me because they say I'm not giving them the right answer. And okay, but my job is to call balls and strikes fairly and squarely, and that's what we've done. We may ultimately see from the court what the answer to that question is.
And your position on the presentment clause, Mr. Wasden, is on all fours with the Supreme Court's decision in 1983, INS versus Chadha, written by Chief Justice Warren Burger, dyed-in-the-wool Republican conservative. And perhaps many who oppose your position aren't aware of that decision. I'm sure you would like to inform them of that.
Yes, and you are absolutely right. What I've said concerning presentment is precisely on point with the language of the Constitution and with case law.
In our final minute together, and I'm so sorry our time's gone by so quickly, we need to win your assent to a return visit very soon.
I will indeed.
You have been in the office of Attorney General now for 30 years, roughly. As your perspective on the duties that you have to perform changed over time? I'm sure there are times in which your shoulders may slump, but what provides you with the energy and the stamina to keep going forth to defend the rule of law?
I have 13 grandchildren. And what motivates me is the fact that I'm trying to preserve, maintain, and foster a world in which they can live under the rule of law, under the same kind of world that I have come from and that I have lived in, that I think protects all of us and our freedoms. And people like to say freedoms, but I'm not sure that they really understand that and the concept that our rights are in fact limited. They're limited because of the way they may affect other people. And so that's what really motivates me, is that the fact that I really believe in a future of the United States. Yeah, we're in a very dark and dismal time. Just think over the last number of years, we had protests in the street 4 years ago over the selection of a president that people didn't like. The media went crazy. We had people who were occupying the Portland courthouse on a political basis. We had people who stormed the U.S. Capitol a few weeks ago. All of this stuff is really contrary to the concept of the rule of law. It's really contrary to dual sovereignty. It is separation of powers. It is really contrary to what we as a constitutional body believe in. And I actually have hope for us. Yeah, we have some dark times, and we've overcome dark times, and we will still continue to over dark times as long as we're willing to hold to those constitutional principles. And so my job, my hope is that we continue to understand that it's not just say we believe in the Constitution, actually read it, actually understand it. I invite people, when you don't understand what I'm doing, call me and ask me. I got a lot of calls during this Texas versus Pennsylvania thing. Most of them were nasty, mean, aggressive, vulgar. They weren't people interested in understanding a different viewpoint. Differences of view actually are a healthy thing for our system. It is understanding. That doesn't mean you have to agree, but at least listening and understanding, talking to people is what happens. I remember a conversation that you and I had a long time ago, Dr. Adler, in which you asked me a similar kind of question. And I said, well, really the facts and the law should drive our decision making. And that's still what I believe. And that is the rule of law. What are the facts? What is the law? If we don't like the law, we can change the law.
Rule of law and American constitutionalism, those sound like good principles to end this program, which has gone by all too quickly. We can't thank you enough. Ladies and gentlemen, I know that you're right now offering loud applause for the Attorney General of Idaho, Lawrence Wasden. Thank you again, Mr. Wasden, for joining us. And ladies and gentlemen, don't forget our next program on February 26th. We'll see you then. Until then, stay safe. Thank you very much.
Thank you, Doctor. Appreciate it very much.
Thank you.